If there's a disagreement in your family about what to do with an inherited house, this video is for you. Sibling conflict over inherited real estate is one of the most common situations I work with, and unfortunately it's one of the most painful. Stay with me. Let me start by saying something clearly. If your family is in disagreement right now about what to do with an inherited house, you're not alone. The situation is genuinely hard. It sits at the intersection of grief and money and a lot of shared history. So that combination almost always produces some form of conflict. My name is Ryan Smith. I'm a licensed realtor and certified probate expert. And every day I work alongside families navigating probate and estate administration. I work with families in this situation regularly. Families where real estate has become the center of a disagreement that feels like it may never get resolved. Thankfully, in my experience, almost all of them do. This video isn't designed to take sides. What it will do is help you understand what's happening, what the consequences of unresolved conflict look like, and what the path forward actually is. Let's get into it. Let me explain why this situation is so common, because understanding why it happens is, in my experience, the first step towards resolving it. If you're in this situation, I'm sure you've already concluded inherited real estate isn't just an asset. It's a family home. It carries memories, it carries identity, it carries the weight of someone who is no longer here. And that's not true of a bank account, right? Or a car, or a piece of jewelry, though I've seen it happen with jewelry too. When someone passes, the heirs are grieving. And in the middle of all that grief, they're being asked to make major financial decisions about something deeply personal. That combination almost always produces conflict, not because people are selfish, but because grief and money are both extraordinarily difficult things to navigate. And they're being asked to navigate them at the same time. Everyone's relationship to the property is different. The sibling who spent the most time in that house has a different emotional relationship to it than the one who moved away years ago. And the one who lives nearby has a different perspective than the one managing this from afar or from out of state. And inevitably, old family dynamics resurface. Decisions about the house stop being just about the house. And none of this means that anyone is wrong. It just means the situation is genuinely hard and it requires the right kind of guidance to navigate. Let me name some of the most common situations that I see in working with families. Because one of the most disorienting things about family conflict is feeling like your situation is unique. And thankfully, in my experience, it usually isn't. Scenario number one sibling wants to sell and the other one wants to keep the house. Obviously, this is one of the most common scenarios. One of these individuals needs the money or doesn't want the responsibility of the home, and the other can't imagine letting go of the family home. So both positions are understandable. Neither one is automatically right or wrong. And without a resolution, the estate stalls and carrying costs keep running for everyone. Scenario number two is a sibling is already living in the house. Sometimes they're paying expenses. Unfortunately, sometimes they haven't been paying expenses. So either way, other heirs feel the situation is unfair. One person is benefiting from a shared property while everyone else is waiting. The heir in the house may have a real reason to be there. They may have been the caretaker or are a caretaker. They may have no other housing, or they have a particular history with the property that makes it difficult to leave. But the situation needs a formal resolution because it almost never resolves itself. Scenario number three is one sibling has been handling everything. The funeral, the paperwork, the property. Other siblings or heirs weren't involved, and now they want a say in all the decisions. So the one who carried the weight typically feels resentful and the other ones feel excluded. And oftentimes this is where I see trust break down. Scenario number four is everyone agrees to sell, but they can't agree on the price or the timing or which offer to accept. So even a shared goal doesn't guarantee a smooth process. Whatever your situation, if you recognize yourself in any of those, what comes next is what you need to know, and I hope will offer some guidance. First, let me be honest about what happens when families can't reach an agreement, because understanding the consequences is often what finally motivates a resolution. First of all, the estate will stall. If heirs can't agree on what to do with the property can't move, it can't be sold, it can't be transferred. The estate stays open, sometimes for months, and many times I've seen it stay open for additional years trying to resolve this. And during all that time, carrying costs continue. Mortgage payments if there's a loan, property taxes continue, there's insurance, and of course there's maintenance. And all that keeps running, and all of it ultimately comes out of the estate. The property itself may and oftentimes does deteriorate, because a house that's under dispute often gets deferred maintenance. No one wants to spend money on something that no one can agree on. So that deferred maintenance costs everyone when it comes time to sell. Additionally, legal fees are going to accumulate if attorneys are involved in resolving the dispute, which is often the case, and the estate shrinks while the conflict continues. And the family relationships suffer. In my experience, unfortunately, the conflict over the house often outlasts the estate process itself, and that conflict creates damage that can last for years. So I'm not telling this to alarm you. I'm telling you because most families, once they understand the full picture, they genuinely do want to find a resolution. There's one more thing you should be aware of, and that is, if the conflict escalates far enough, there is a legal mechanism that changes the equation entirely. It's called partition action, and it's important that you understand it, whether you're considering it or someone else might use it. Here's how it works. When multiple heirs co-own real property and they can't reach an agreement, any co-owner can file a partition action in court. That means any co-owner or even a minority owner with just a small share. What does the court do? Well, the court has two options. They can physically divide the property, which almost never happens with a house because a house can't be meaningfully split. Or the court will order a sale. And in practice, the court almost always orders the property sold. And this is called a partition by sale. That sale typically happens through a court supervised process, and it usually happens at or unfortunately below market value. And here's what it costs everyone. There are the legal fees on both sides that come out of the estate proceeds. Everyone pays. The timeline is slow. Partition litigation can take a year, sometimes more. And as a result, everyone ends up with less money than they would have received from a voluntary sale. And then there's the impact of the family relationships. Partition actions are adversarial by design. The process resolves a legal dispute. It doesn't preserve the relationship. So most families that go through partition come out with the significant hard feelings in the end. It's not always the case, but it's a common reality. Understanding what partition is and what it costs is often what motivates families to find a better path before it gets there. Most families in disagreement don't actually want to go to court. They want a resolution. The problem is they don't know how to get there. Here's what a better path actually looks like. Step 1, get neutral, experienced guidance. That means not another family member's opinion and not a one-sided attorney retained by one of the heirs. You want someone who's helped other families through the same kind of disagreement, someone who understands the property, the probate process, and the realistic options. Step number 2 is understand the full picture. That means, what is the property actually worth? What would each path cost? What would each heir actually receive under different scenarios? Most agreements are rooted in partial information. When everyone is looking at the same facts, the path forward becomes clearer. Step 3 is to explore middle ground options, like mediation, which is a formal or informal process where a neutral third party helps heirs reach an agreement without going to court. It's often less expensive, it's faster, and it can do a lot to preserve the relationships. Another option is buyer financing. So if one of the heirs wants to keep it and others want to sell it, financing exists specifically for this situation. The goal isn't for any one heir to win, it's for the family to reach a resolution that everyone can live with. I work with families in this situation regularly. If you need a mediator, a probate attorney, or you just want to understand the realistic options, I can connect you. If you're a personal representative in a contested estate, I'm speaking directly to you. You have a fiduciary duty to all the heirs. That means that you're legally required to act in the best interest of the estate. Not the loudest heir, not the most persuasive one, not even yourself. And in practice, here's what that means. First and foremost, document everything. Every decision you make, every communication with heirs, every expenditure, make sure that's documented somewhere. This way, if your reason is ever challenged, and it often is, you'll have the documentation to defend it. Also, know your authority. As an executor, you genuinely have the authority to list and sell real property. But obviously, with a contested sale, it's more complicated than a cooperative one. So talk to a probate attorney before you list a property that's subject to an active heir disagreement. And understand this, just as a reminder, you're not required to make everyone happy. You're required to honor your fiduciary duty. And unfortunately, those two things are not always the same. I'm not an attorney. This is educational information based on my experience in working with families. I always highly recommend meeting with an attorney that's specialized in probate and estate administration in the county where the estate was opened. If you need a probate attorney who specializes in contested estates, reach out and I'd be happy to connect you. And when the family's ready to explore the real estate options together, I can help with that too. Thank you very much for watching. I hope this made the path forward a little more clear. Reach out anytime. I'd be happy to help.